Hello friends, in the series on the income tax cases, today we will discuss a very important issue for levy of penalty under section 271 subsection 1 clause C for alleging that the assessee has furnished inaccurate particulars of income. Whether in any case or in every case where the addition has been made in the case of the assessee and the assessee chooses not to contest the matter further, it can be said that the assessee has furnished inaccurate particulars of income and the penalty should be levied on him. The answer is big no, because for levying penalty, it is a tried law that penalty proceedings are separate from assessment proceedings, and whenever the penalty is initiated or imposed, it should be proved beyond fact that the assessee has some malified intentions or the assessee has furnished inaccurate particulars of income. A case can be a perfect case for addition, but whether at the same time it is a perfect case for imposing the penalty or not, it depends upon the facts and circumstances of each case. This case is to be understood in the sense that whenever the additions are made and the assessee chooses not to contest the matter, then it cannot be taken as a straitjacket formula that it is a fit case for imposing the penalty. The name of the case is Anjali, Neeraj, Hardikar versus National FACELESS Assessment Center, and this case has been reported in 111 ITR short note 15, and the matter has been decided by Mumbai ITAT A bench, and the date of the judgment is 18th March 2024. The facts of the case are very interesting. In the present case, the assessee claimed a deduction of 10,50,000 under section 80 GGC. And when the assessee claimed this deduction was claimed on the basis of the opinion of the auditor. Auditor is generally a professional, and whatever the deduction has been claimed, that deduction has been claimed on the advice of an expert. But when the assessment proceedings were going on, the learned assessing officer was of the opinion that the assessee is not eligible to claim the deduction, so he disallowed the deduction. When the assessee filed the appeal for this disallowance to the CIT appeal said that the claim made by the assessee was bona fide and he deleted the addition. The revenue moved to the tribunal, and the tribunal remanded back the matter to the assessing officer to re-verify the claim. In the second round of litigation, the assessing officer again disallowed the deduction under section 80 GGC, and at this point of time, the assessee chose not to contest this matter any further, because the cost of litigation is always very high, not always in the terms of money, but in the terms of harassment also. When the assessee chooses not to contest the quantum matter, the department moved to the penalty proceedings and imposed a penalty of 100% of the tax on an addition of 10,50,000. The assessee moved to the CIT appeal against this penalty order. Now the CIT appeal, who was the same, upheld the penalty, and this CIT appeal in the first round of litigation has held that the claim made by the assessee was bona fide. This is the irony of the income tax proceedings, that the same CIT appeal is taking the two stands in the case of the assessee. Now the assessee moved to the tribunal against the penalty order which was confirmed by the learned assessing officer, and the tribunal said that in the present case, this is not a fit case for saying that the assessee is furnishing the inaccurate particulars of income. The reasons for saying so is that the assessee has believed on the expert advice of the auditor. In the first round of litigation, the CIT appeal himself has admitted that the claim made by the assessee was a bona fide. The penalty should not be levied on the assessee just on the basis that the assessee has chosen not to contest the quantum proceedings. So the quantum proceedings are not a final verdict for levying the penalty on the assessee. So each and every case for the penalty should be seen from a separate angle because levying the penalty has the civil consequences and imposing the penalty involves a large amount of tax or in the form of penalty. So the penalty should be seen from a different perspective, not the same perspective of the addition. At the end of this video, once again I am repeating the name of the case. The name of the case is Anjali Neeraj Hardikar versus National Faceless Assessment Center, and this case has been reported in 111 ITR Tribunal short notes 15, and the matter has been decided by Mumbai ITAT A bench, and the date of the judgment is 18th March 2024. Thank you friends.